the named administrator, but that doesn't mean a thing until you submit it to the probate judge. Until the probate judge sees that will and approves it, it's just a nice piece of paper. And that's why if you look in the probate or the legal notices in the paper, you'll see sometimes some probate notices. It's what I call the sue me notice. Because if you ever read it, it says, if you ever have a claim, please file it. So, does that mean that then wills and probates are public? The answer is, yes, they are. And before the internet, you actually had to go to the courthouse, talk to the register and probate, ask to see a file. Not anymore. It is all online. CCAP. It's available. It's a public record. I'm doing a probate down in Milwaukee right now. We filed the petition for probate. The next day, we were getting emails from unknown people soliciting us to sell the house, sell the car, sell the personal property. These folks must literally surf the probate records and just send things out randomly. And there's nothing we can do about it. It is a public record. So if you're interested in privacy, wills are a little bit of a concern. The other thing where wills are a bit of a problem or a misunderstanding is there's a lot of assets that don't necessarily go through probate. They're not governed by the will. Joint assets. So let's use Bob and Cindy again as the example. Bob and Cindy have their home. Bob dies, it goes to Cindy. If in our will, I had an instruction that I want some of that going off to children, it is not going to happen. Because that asset is not going through probate. Joint ownership, the way it is titled, says where it is going to go. And there's two other very major assets, bless you, that do not go through probate. Life insurance and retirement plans. And the reason they don't go through probate is, how do you decide where your life insurance and your retirement plan goes? Beneficiary designation form. In your folder, there's an article I wrote called The 6 Biggest Beneficiary Designation Mistakes. Why did I write that article? Because your will and your trust cannot change where those assets go. The beneficiary designation form is the critical form. And if you take that article when you get home and read it, but the opening paragraph talks about a case called Kennedy versus Dupont. Mr. Kennedy worked for the Dupont Corporation, and they had a retirement plan, and he was married. So who was named as the primary beneficiary? His wife. Well, guess what happened? He got divorced. So in the divorce decree, his wife signed a waiver of any interest in that plan. The court issued an order removing any interest she had in the plan, and they sent that order off to the plan administrator. Mr. Dupont died. What's the one thing he did not do? He did not change that beneficiary form. This case went all the way up to the United States Supreme Court. If you think one lawyer is expensive, wait till you have a bunch of them going all the way to the U.S. Supreme Court. And the Supreme Court ruled, we don't care that she signed a waiver, we don't care that the court signed an order, giving it all to him. He didn't change the beneficiary form, that rules. So is that form critical? You bet. And just to give you another little story, I had a friend of mine who got divorced 25 years ago. Remarried 20 years ago. He came in to see me. He promised me he had changed the beneficiary to his new wife. Well, experience has taught me. And I said to him, show me. I don't believe you. He came back a week later with a very sheepish grin on his face saying, Thank you. He had not changed it. It was still his first wife. Imagine that conversation had he died. So that's why that form is critical. So, yes, Virginia?
What about property like cars? I mean, my car is in my name, my husband's in his name. Those would transfer just because we were married if one was died?
The question is, if you have a car and it's just in, say, the wife's name and she passes away, will it automatically go to the husband? Not necessarily, but there is a way in Wisconsin to transfer vehicles if their value is under $50,000. So for most of us, that's not a problem. It's a very simple affidavit for transfer of property. And there's a special MVD form for that. So car titles can be changed relatively easily without having to go through a formal probate. Good question. So the other thing that's important with beneficiary designation forms is, can you find the form? And the problem we're having is, if you can't find it, your family probably can't find it either. Do you think the plan administrator can find it? Don't count on it. Because how many of you have had your plan administrator changed? You know, back in 2008, when all these companies too big to fail did, and so things got merged, they got sent. So let's just imagine there's a company out in Atlanta, Georgia, saying, we're moving all of these forms. Oh, here's Bob Ross's form. This is really important. We got to make sure we maintain this. I don't think so. You know, and this digital age, the problem we're running into, if that's not scanned into the computer, most of these folks that work for these companies don't necessarily have the greatest amount of training. They are not going to go look for a lot of those old forms. And so many companies cannot find them. So is this time of year an absolutely perfect time of year to review those beneficiary forms? You bet. Why? Because you've got it all out, getting ready for taxes. You're looking at all of this stuff. So pull it out. Look at it. Does it say what you want? Has anything changed in there? Has something changed in your life? You got remarried. You got divorced. You inherited something. One of the kids got divorced. Something else happened to one of the kids. Heaven forbid, people died out of order. You know, we're supposed to have our kids come to our funerals. We're not supposed to go to theirs. But we're seeing that happen more and more today. So if any of those changes have happened, is that a good reason to change your beneficiary form? You need to take a look at it. And another one that I have a lot of fun with, and that's for couples, I'll frequently see that they will name each other, that's appropriate, and then they'll name the kids. But the kids, some of them are minors. So what happens if they're under the age of 18? The judge will manage it till they're age 18, or in some cases, age 21, depending on how you set it up. But even at age 21, I mean, I was a really good steward of my money back when I was that age. If somebody handed me a bunch of money, it would have lasted 2 weeks. You know, for us guys, there'd be two questions. The nearest car dealership, and what color? You know, I'm going to Corvette University. So you need to be very careful about that kind of thing. Who's going to end up with those things? So that's why I put that article in there for you to think about it. Because that is what's called a non-probate asset. And where you need to be really careful also with retirement plans. And I'm seeing retirement plans being larger and larger portions of people's estates. They are an income tax bomb waiting to happen. Because if you have a retirement plan, for the most part, what happens when you hit 70 and a half? You gotta take money out, right? It's called required minimum distributions. And I've had several clients come in and say they've hit that magic 70 and a half. They've gotten a letter from the plan administrator that says they gotta take some money out. They come into me, do I have to? I really don't want to, because I don't want to pay the tax. I go, well, no, you don't have to take it out. The penalty's only 50% if you don't. So, yeah, you have to take it out. And when you take it out, it's taxable income. And spouses, there's a very special rule in the code that says a spouse can roll over a retirement plan tax-free. It's not a taxable event. But can children do that? The answer is no. There is something that children can do. They can stretch it out. Now, don't run to the bank and say, Bob talked about a stretch IRA, we want one. It's not something you can buy. It is the way you set up your beneficiary designation form. And what that means is, upon your death, we can take that IRA, and if there are 2 children, we can split the IRA in half, and each child can then take it out over their life expectancy. That's the stretch. We get to deal with that income tax hit. But what's the difference between an inherited IRA and a rollover IRA? If a child tries to roll over that IRA into their own IRA, that's considered a distribution. You owe the tax. The other difference is, with an inherited IRA, even if that beneficiary is your grandchild and they're age 10, they must take something out every year. It's called a required distribution. And I was out in San Diego a couple of years ago reading through the paper, and there was a letter to the editor in the financial section. And there was a young man who wrote in saying, I just inherited an IRA from my uncle. Do I have to take money out every year? And in the paper, by somebody who supposedly knew what they were doing, said, no, you don't have to until you're 70 and a half. And we said, you're right. When you're 70 and a half, there won't be anything left to take out because all the penalties will have taken it all. You need to be very careful. IRAs, retirement plans have lots of rules. You just need to be aware of it. And the headache with beneficiary designations, and why it's important to review them, is you want to name backup beneficiaries. Because if you don't, in many cases, the plan provides a default beneficiary, and that's your estate. And now if we send your retirement plan into your estate, you're now going to be subject to those probate fees, and you pretty much lose any option to stretch it out. You got to pay the tax. And something that I am after many of my clients is don't wait till you're 70 and a half to start taking out. Start taking things out now. Why? Does anybody think income tax rates are going down? If you do, I'm sending you to Washington. I think they're going up. And they've already gone up. And the problem is, the more you defer, you're going to be taking out money when those tax rates are going up. So if you actually take it out now, you can start dealing with that income tax problem now, when rates are lower. And again, this is the ideal time. It's tax time. You have all of those records out. You can be looking at this. Can I actually take a little bit more out? Yes, you're going to have to pay some tax on it. But are we going to pay less tax by taking it now rather than more tax when we take it out later? Because the whole theory of IRAs and retirement plans was put the money away when you're in this high tax bracket. And so that when you retire, you're going to be in this lower tax bracket. I have found with far too many of my clients, they're not in any lower tax bracket after they've retired. Sometimes they're even in a higher tax bracket because of what has happened. So this idea of defer, defer, defer has not worked. Now, is there another option that you can do? And that's, can you take the money out Hopefully, everybody's familiar with something called a Roth IRA. If you're not, the difference between a regular IRA, which is the money that goes in is before tax, so whenever you take anything out, it's after you got to pay the tax on it. A Roth IRA is money that's already been taxed. So when you take it out, it comes out tax-free. And it's not only the contribution, but any earnings or growth also comes out tax-free. So you need to think about doing some of those Roth conversions. I've been after folks to think about that for a long time, because there is one important difference between a regular IRA and a Roth IRA. And that is when you hit 70 and a half, you're not required to take anything out of a Roth IRA. But a lot of folks ask me, now somebody has passed away and the children have inherited the Roth IRA. Are they required to take something out just like the regular IRA? The answer is yes. But it comes out tax-free. So you have a choice of inheriting a regular IRA or a Roth IRA. Which do you prefer? I think that's pretty easy. So it's just something I like to have folks think about. But a Roth IRA is, again, it's a regular IRA. You've got to look at your beneficiaries. Wonderful beneficiaries of Roth IRAs are grandchildren. What a wonderful school or even a retirement program. If you like to play with numbers, let's say you went to your investment advisor and say, we're going to leave something to a 10-year-old grandchild. What's the life expectancy of a 10-year-old? 70 plus years. And maybe by the time they're 70, it'll be 100 plus years. So you go to your investment advisor and say, you have a 70-year time horizon to invest these funds. Do you think they can get a little more than 0.2% that we're getting on CDs today? I would think so. And what's the required distribution for a 10-year-old? It's about 1%. So if they're taking out 1%, and if this plan is even conservatively growing at 5%, what's going to happen over that lifetime? It can be a significant amount of money. So it's just a planning opportunity. I like to get folks to think about this. Okay. So, with a will, I digress. Pardon me, I go all, yes?
Regarding Roth and regular, can you take out the regular and pay your tax and then put it back into Roth or not?
Yes. It's called a conversion, where you take the money and it goes from your regular IRA direct to your Roth IRA.
Pay your tax.
And pay your tax. Stop at the IRS window, pay your tax, but then yes, that can go into a Roth IRA. Now, and the way you get larger sums into a Roth IRA is doing that conversion, because you are limited to how much you can actually put in if it's just a contribution. To put things into a Roth IRA, you have to be working, and right now it's limited to, for those of us over age 55, it's about $600 or $6,500 a year that you can put in. But to do a conversion, there's no limit. And if you're going to do a conversion, you have to do the whole IRA. The answer is no. You can pick and choose how much. You can do some this year, you can do some next year, you can do some the following year. And what you do is you sit down with your tax preparer and say, how much room do I have left in my tax bracket? Let me fill that up with that Roth conversion before I go into the next tax bracket. So you can look at that. You can manage the tax hit on that. Yes?
You don't have to be working to do the conversion.
The question is, do you have to be working? The answer is no. No. To contribute to it, yes, you have to be working. But to do the conversion, anybody can do that. Any age. And several years ago, there was actually an income limit. You couldn't have more than $100,000 of adjusted gross income. If you were over that, they wouldn't let you do the conversion. Well, they got smart. They said, there's a lot of folks who have income more than $100,000 who can do this conversion. And why would they want to encourage you to do the conversion? They get the tax money. And they get it now. You know, one of the things I am concerned about is this stretch IRA. There's billions and probably trillions sitting in retirement plans untaxed. What's happening out in Washington? They are looking for ways to raise tax dollars. Could they very easily come in and say, other than spouses, if a retirement plan is going to go to somebody other than a spouse, you must take it out over 5 years. And am I speculating on this proposal? No, it's already been proposed. Hasn't gone anywhere yet. But there's a lot of folks out in Washington looking for ways to raise tax dollars. And they're seeing all this money sitting in retirement plans untaxed. So just keep an eye out for that. Watch. But since we're in tax preparation time, look at some of these things. Sit down with your tax preparer. Now, frankly, they're not going to have the time right now to sit down and do the analysis. Make the appointment after April 15th. Then they'll have a little bit more time to sit down and do this with you. But please, by all means, do it. It's important. Okay. So the reason I digressed was because beneficiary designations don't typically go through probates. So you've got the will, you're going through probate, it's a public record. So now, how does a trust work? Well, a trust is also a set of instructions of where you want your things to go. So it works in that way very similar to a will. But there's a couple of major differences. We call it revocable living trust. It is set up while you're alive. Revocable means you can change it. And so we put your things into this trust. And in my office, when we set up a trust, I will require that if we're going to work together, that we actually put things into the trust. Because I have reviewed far too many trust plans where there is nothing in it. That is like buying a brand new car and never putting any gas in it. Would you do that? No. And so in my office, I insist that if we're going to work together, we're going to do a trust, we're going to put things in it. Folks at the bank are used to hearing from my office. We are constantly making sure things get into the trust, because that's how it works. So in the trust, it's your instructions. Now, does a trust have to file a tax return? The answer is no, as long as you're alive. My wife and I have had a trust for about 15 years. We still file the tax return just like we do now. Doesn't change your lifestyle. But what can I do in that trust? I can put those instructions about how and where you want to be cared for if you become incapacitated. I can also put those funeral instructions in there. I can put where things go upon your death. I can do an awful lot of things in that trust. And one of the other major differences between a trust and a will is upon your death, what goes over to the probate court? Nothing. It is a private plan. It is not something that's available online. And so we like it because the other nice thing that happens is accounts are not cut off. They're not frozen. In a will, if I die and Cindy's already passed away, so now it's going to go to our kids, who can sign my checks? Nobody. Until that will is submitted to the probate judge and he appoints somebody to be in charge, all those accounts are frozen. That does not happen in a trust. A trust does not die. A trust is kind of like a corporation. You know, if the president of General Motors died, Do all activities of General Motors come to a screeching halt? The answer is no. Same thing in a trust. You as the trust maker, the positions. In our office, we call them the trust maker. That's you. You made the trust. You set it up. There's the trustee, who's in charge. And there's the beneficiary, also you. So in the Bob and Sarah inherit. Now we talked about some of the difficulties that kids can have. You know, if we just leave things to kids and now they get divorced, you know, I have a lot of families that come in and say, well, I never named the in-law. I only named my children. Well, let's go back to joint ownership. Once they got it, what did they do with it? They put it in joint ownership. So now the divorce happens. Where does your stuff go? Well, maybe half goes to the other one, maybe more. Kind of up to the divorce judge. Who's got the best lawyer? Do you want to protect from those kinds of things? That's why I always talk to folks, and in my office I call them castle trusts. Why were castles ever built? For protection. I like to make sure that those inheritances are protected. And the big three we protect from are divorce, creditors, and serious health issues. And I have a case in my office right now where a daughter who was in her late 40s got divorced and just had some real difficulties and is now qualified for Social Security disability income. There's limits into the assets that you can own under that program. Now mom dies, and she was going to inherit a fair sum of money that would disqualify her from all of those programs. We had actually put in place a backup standby special needs trust so that she doesn't lose all of those benefits, and so far it's working. She has maintained her benefits, and this inheritance is set aside in a special trust where the funds are restricted as to what they can be used for. So she doesn't lose her benefits. And those are some things that, you know, you got to plan. We got to think about those kinds of things. And we got to talk about that stuff in your planning. But that's where I'm going to inherit in a protection trust. I'm well past the age of 21. I mean, my youngest son is past the age of 21. Matter of fact, my oldest granddaughter is older than 21. But yes, I'm going to inherit. Why? Because I'm concerned about the world out there. There's always somebody trying to take something away from you. And I've got grandchildren who are now starting to drive. And if they take Grandpa's truck and they get into an accident and they're at fault, who's going to get sued? So I want to make sure that anything that I inherit is protected from that. And we've all seen cases like that right here in Door County, where a young person, I mean, you know, not out drinking, fell asleep at the wheel and killed somebody. I mean, it's tragic. But how do we protect that inheritance from that? So in planning, you can do that, and that's one of the nice things you can do in a trust. Can you do those same things in the will? The answer is yes. The difference is the probate court will be overseeing those for the term of that trust. So you're going back to that probate court annually filing reports. Whereas under the trust, again, we're not going to the probate court. It's a private copy. And we can put those people in charge to take care of things that we want. So that's some of the big difference. Now, a lot of times I'm asked, what's the difference between a revocable and an irrevocable trust? The major difference is a revocable trust you can change. An irrevocable trust you can't. Now, why do you ever set up an irrevocable trust? Well, one of the things I said I would talk about is medical assistance planning and how do we preserve assets from the nursing home. Well, one of the ways of doing that under medical assistance planning, you know, you're restricted as to how many assets you can have. And currently, we need to talk quickly about if there's a husband and wife, can you lose everything? The answer is no. There are certain assets that are exempt. Your home, as long as one spouse can live in it, is exempt. A minimum of $50,000 is exempt, and we can actually move that number up to about $117,000 is exempt. We can set up a funeral trust for you, that's exempt. You can have a car of any value, that is exempt. So there's a fair number of assets that, as long as there's a spouse at home, that are exempt. But what if you're a single person? What is exempt? Almost nothing. You can have a checking account of $2,000, you can have a car of $4,500, you can have a life insurance policy of $1,500, and you can have a funeral trust, and that's it. So a lot of folks come into me, regularly they're coming into the office, we're concerned, we don't want the nursing home getting my home. Well, first of all, the nursing home doesn't want your home. They are not going to take it. They only want one thing, a check. Now, anybody have any idea what nursing home costs are a month?
$3,000.
$3,000?
I don't know, 6,
7 plus. Assisted living can be $3,000 to $4,000 a month. Nursing homes are about 7. And we're very fortunate in Door and Kewaunee County. We have some of the most reasonably priced long-term care nursing facilities in the state. You go down to Green Bay, it can be $9,000 or $10,000 a month. You go down to Milwaukee, it can be $12,000 to $15,000 a month. And folks are always asking me, what can I do? Well, one of the things that I can do is actually give assets away. And under medical assistance planning, that's partly what we do. But a lot of folks come in and say, well, let's just give them to the kids. I go, well, remember back, we talked about the divorce rate. If the kids get divorced and you've given your stuff to the kids, what's going to happen to it? Well, they'll give it back to me. Okay, that's not going to work. So why we set up irrevocable trusts is we make the gift into this irrevocable trust so that it's then protected both from nursing home and the creditors of the kids. So that it is available for your special needs.